Hi, everybody, and welcome to our live stream. This is our first live stream. We're really excited to have you all. But again, like I say, it's our first one, so just bear with us. My name is Brandy McGee. I'm with the London Tenants Association. We also have here Jessica Burgess. She's also with the London Tenants Association, and we're going to moderate the panel discussion for you. We have an excellent panel. There's Jessica. We have an excellent panel assembled here for you today. Before I introduce them, I just want to put out a really sincere thanks to the London Poverty Research Centre. They've been such a support through so much for the London Tenants Association, but particularly getting this webinar together for you guys. It couldn't have been done without them. So thanks to the London Poverty Research Centre. Without any more delay, I want to introduce to you our panelists. We have three panelists here today. We have Olaire O'Malley, and she's a staff lawyer at Neighbourhood Legal Services. That's a legal services. There she is. Hi, Olaire. It's a clinic here in London, legal clinic. We have Betsy Espa, and she's a licensed paralegal, and she also works at Neighbourhood Legal Services. Hi, Betsy. Thank you. And our third panelist today is going to be Ian Dancer, and Ian is review counsel at Western Law. Hi, Ian. Thanks so much to the three of you for joining us. We really appreciate it. And we have some questions for you from the live audience, and we have some others prepared. I'll just tell the audience quickly before we get going. We want to remind you that the panelists aren't able to provide you legal advice. You know, to give you legal advice, someone would sit down and listen to your case in more detail. So if you are in need of legal advice, please check the links. We're going to paste links to all of the agencies that we talk about today. And just bear in mind that the panelists are giving general information about the Residential Tenancy Act and tenants, what they need to know at this time. So I think I'd like to start with Olaire, if that's okay. Olaire, could you tell us a bit about Neighbourhood Legal Services and what you do there?
Sure, yeah. First, thanks for having us. Betsy and I are from Neighbourhood Legal Services. We are a poverty legal clinic. We are funded by Legal Aid, and it is for low-income Ontarians. So our services are free, but we do some income testing. So a few areas of law that we do are social assistance. So these are your Ontario Works and disability. We also do CPP or Canada Pension Plan disability. We do some housing, particularly tenant rights, mostly representations for people who are at risk of losing their RGI. So we also do employment law, so for wrongful dismissals and termination, and some affidavits for housing and social assistance. So currently, because of the COVID-19, we don't do affidavits, but our office is still open in a sense that we still answer phone calls, and we do intakes over the phone. We are all working from home. Our receptionist comes in every day, and I think that's a good relief for some people that someone answers the phone. So so you can reach us by calling our phone number or emailing us. So I think there's a link, so nlslm.com. That's where you can find us. Thank you.
Thanks very much for that. It's operational, and we'll hear more about that in a bit. Thank you. Ian, I'd like to go to you next. Can you tell us a little bit about the community legal program at Western and what they do in the community and at the schools?
Now that I'm unmuted, I can, yes. Well, welcome everybody. Thanks very much for joining us. It's great to reach out to the community that needs us and that uses us. As you heard, I'm a lawyer. I have practiced for about 38 years, and the last 3 I have been at CLS, which is part of the Western Law faculty, and it's a clinical education program where students as caseworkers work under the supervision of us as review counsel. We do family law, but on a very limited basis, criminal, and of course housing, which is why we're here today, and that's what I do, mostly housing. So in fairness, I only represent tenants, primarily students, We represent students free of charge at both Fanshawe and Western, no matter their income or resources. It's part of their service, that exorbitant $5 a year they pay. And as well, we are funded by Legal Aid Ontario and the Law Foundation, so that people who qualify on an income basis are also given the same access to those services, including housing law. So I look forward to your questions tonight and a discussion, and I'm very curious about how everyone's doing in this very difficult time.
Yes, thanks for that. It'll be really great to check in with what's going on for everybody. I'd like to ask you, Betsy, next. I understand that Duty Council does work, Tenant Duty Council at Neighborhood Legal Services. Is that Wednesday to Friday? Can you tell us a little bit about what Tenant Duty Council Services is?
Yeah, certainly. So Tenant Duty Council is actually a program that runs province-wide through the Advocacy Centre of Tenants Ontario. So it's funded by the government to provide free legal advice to all tenants in Ontario. For London and Middlesex, Neighbourhood Legal Services, our office, provides a Tenant Duty Council service, and any tenant that has a question about their rights, responsibilities, or has a hearing and needs some help and advice about their hearing can get advice for free through our office. It's completely independent from the Landlord and Tenant Board, but you can find our Tenant Duty Council at our office typically Monday to Wednesday, and then, Monday and Tuesday at the Landlord and Tenant Board, and then Wednesday to Friday at our office. However, because of COVID-19, things are changed a little bit. We are still available to provide free legal advice for all tenants by phone or by email, just by contacting or going to our website. You can access our email or calling in. And all tenants can receive legal advice. There's no income testing, so there's no cutoff for who or what tenants can get legal advice from us.
That's great. Can I just clarify? So are tenants able to email with Duty Council right now at this time, or to have phone calls? I just wanted to clarify. Yeah. Okay, great. Yeah. Thank you. I'm seeing some people jump in, and they're recognizing faces on here, so that's great. We'll do just a little bit. We wanted to check in with our panelists about what all has changed in this time, and I'm not sure. I think the panelists do have something else to add about what's changed in this time. Maybe I could just in terms of services, or what has changed in terms of what tenants are asking about, and what do you think people need to know? Just sort of the general. If I could start with you, Betsy.
Certainly. Well, it's important to know first that most agencies are still open and available, just typically not by walk-in service. So if there is an agency that might be helpful to you at this time, you will probably have to phone in or email them as well in order to gain services. And agencies are just functioning in a little bit of a different way, but by and large, all of the normal services are available to you. But one of the big exceptions is the Landlord and Tenant Board. The Landlord and Tenant Board, although it's technically open, is holding almost no hearings, at least compared to what they normally would do. Before COVID-19, we would see on average about 100 hearings a week for London and Middlesex at the Landlord and Tenant Board. For about a month, all in-person hearings have been suspended. So anyone that had a hearing scheduled has had that hearing temporarily postponed, and many tenants don't know, and landlords don't know, when that hearing will be scheduled again. There are select hearings going ahead by telephone, and those are for very few and what's deemed urgent matters. From a landlord's application perspective, some applications are being given telephone hearings when there is an allegation of serious impairment of safety or an allegation of an illegal act, and those are getting into telephone hearings. We're starting to see those trickle in for the May docket scheduling. And for tenants, the most urgent matters that we are seeing being scheduled are illegal lockouts, also known as an illegal eviction. As you may be aware, as most people are aware, and as Doug Ford has proclaimed, there are no evictions happening at this time. That's mostly true in that the Landlord and Tenant Board are not issuing any eviction orders at this time, and the sheriff is not enforcing any eviction orders at this time. But if a landlord takes it upon themselves to change the locks, which they are not supposed to do, that could be an issue that tenants are seeing that this time. If a landlord is concerned that they're not otherwise able to get a tenant to move out at this time, there is some concern about an illegal eviction. So that is something to be mindful of, that if the landlord is threatening to illegally evict you, I would advise you to contact our office right away, hopefully to intervene and to assist you. And I also just want to make a brief note to say, well, we talk about landlord and tenant pretty liberally. Not all tenants are tenants that are protected under the Landlord and Tenant Board or the Residential Tenancies Act. So for example, if you rent out a room from the landlord or the person that owns the house, and if you share a kitchen or a bathroom with that individual, you are not protected under the act, and that person can still ask that you leave their home or otherwise evict you, and you are not protected by the no eviction precautions right now.
That's really good information. Thank you. That's good to know of who's protected and what cases are being heard. I want to go both to both of you, Olair and Ian, with similar but different questions. I guess I wanted to check in just sort of overall about what you're thinking, but specifically, Olair, what types of concerns are you hearing from tenants now that you wouldn't necessarily have heard before? Like, we heard about the illegal lockouts. Is there anything else you're hearing from people in this time?
Yeah, so mostly it's about rent. Tenants always come to us asking if, what can they do if they lost their jobs, and are they still supposed to pay their rent? So currently, from a legal perspective, under the Residential Tenancies Act, tenants must still pay. We have heard, so it's about rent. So we have heard about talks on rent relief. I think it was last Friday, the Premier asked the federal government for assistance on residential rent relief after they have rolled out a commercial rent relief program. So yesterday, Monday, Prime Minister Justin Trudeau mentioned that it will be up to the provinces to figure out what they would do for residential rent relief, because the jurisdiction, residential tenancies are under the jurisdiction of the provinces. So given that there's no rent relief yet, there's no rent relief program yet provided by the provincial government, I think it's a good step that they started talking about it, but we'll see how it looks like in the next few days. So another options, or not necessarily an option, but people are just also talking about rent strikes. So what's a rent strike? It's an aggressive way of getting your landlord to listen to you by stopping rent payments. So is that advisable? Well, I can't really advise on whether you should do a rent strike or not, but I can provide you with some knowledge on what the consequences are. So first, it might be successful or not. Your landlord might not listen to you. Second, at the end of the day, you will still be owing that rent. So if, let's say, you choose to not pay your rent for the month of April, you could be looking at an eviction application once the LTB starts hearing cases again on evictions due to rent arrears for the rent for May. So another thing to keep in mind also, if you're going to do a rent strike, is how do your payments look like? before COVID. So if you were persistently late in paying your rent, and then you go through the rent strike, then the rent strike period would be an additional, or would certainly help your landlord's grounds for evicting you based on persistent late payment of rent. So tenants are not, they can also be evicted for rent arrears and persistent late payment of rent. So what I would suggest is that tenants do payment plans. It will depend, of course, if your landlord is a big corporation or a small landlord. It is certainly tough on everyone. It's not only tough on the tenants, it's also tough on the landlords, especially small landlords. So my advice in trying to negotiate is only agree to things that you can comply with and have it in writing. Keep an open mind, be respectful. As people always say, you catch more flies with honey. And then lastly, there's the topic on rent freeze. I don't think the provincial government is allowing for rent freeze, so your landlord can still increase your rent according to the RTA. So that's 90 days notice before the rent increase takes effect. It can only be done once a year, and I forgot the last one, but there's a third requirement for that. So that's rent. Your landlord can also not charge you interest on unpaid rent. And in terms of paying rent safely, it depends on what your contract or your lease agreement says. So if your lease agreement says you can pay by cash, pay by check, it will all depend on that.
That's great. Thank you. That's a lot of information. That's one of the common questions we're having. Just to touch on that while you hit on it is the repayment plans. Before I go to Ian to talk broadly about the times for tenants now, but can we just stay on that a little bit, Olair? Like, what should tenants consider when they're making payment arrangements? And just for one specific example, you know, if tenants are making payment arrangements now with their landlords, is that a binding arrangement? If they later decide that was not a payment plan that they were able to do, could they renegotiate later at the tribunal? Or could you tell us a little bit about negotiating payment plans, just while we were a little bit on there? Sorry.
Yeah, so that's why it's really important for the payment plans or any kinds of agreements that the tenants have with their landlords to be in writing, because eventually, if you don't have it in writing, the landlord can always go to the landlord-tenant board and say that tenant didn't pay the right amount of rent, and they're going to ask for an eviction. The agreement, if it's on paper, would be a source of evidence for the tenant saying, yes, the landlord agreed to me not paying 100% of the rent for certain months due to COVID. So that's, I think, what people should do. And of course, like, rent receipts are important. That's your evidence that you've paid your rent and the amount that you've paid.
Thank you. And I just want to go to Ian more broadly. We've heard that the LTB aren't taking cases. We've heard that, like, these are different times for tenants. What are you thinking of during these times and changes right now that people need to keep in mind, or just what are your thoughts on?
Well, in respect of COVID issues only, all the other issues are very much the same as they've always been. COVID, it's an unusual time or a difficult time for students this time of year at that in the normal situation, in that they have to terminate tenancies, figure out if they need space for next year. Right now, all the classes are virtual, all the exams are virtual. That may be the case all next year. So students who have rented apartments obviously would prefer to isolate at home with their family or whomever and want to get out of their leases. And that's been a problem. Landlords, of course, are counting on the income stream. I have noticed a bit that landlords are very difficult about assignments and subletting. The consent is not to be unreasonably withheld, and I've come across a number of circumstances where students are attempting to sign or sublet where I think the human rights code is being infringed and other difficulties. And that's a very difficult current situation, at least for students.
Thanks for that. We're going to pay attention, especially to the human rights topics that come up tonight people may have. Now, I'm seeing a couple questions here. One was on commercial tenancies, and maybe we could get back to that to see if anybody has knowledge on it, but I'm going to stick with the housing-based tenancy questions for now. I see one from Jeremy that did get answered about whether or not a landlord could charge interest, and definitely that's not an option, as Olaire pointed out. So I want to go to one of our questions now from Jill Frenette. And I'm just going to read the question out, and then I'll see which of the panelists would like to take a stab at it. So Jill says, can you speak about the possibility of tenant activists being accused with, oops, it's jumping on me, sorry, tortious interference. This was mentioned in a U of T online seminar earlier today, and I'd love clarification. I know the RTA has some protection for tenants who want to be advocates and organize, but does it protect us from this tortious interference? And pardon me if I'm pronouncing that wrong. I'll just see if any of our panelists.
I can deal with it. Tortious interference, it's an intentional tort. It means taking steps to interfere with someone's economic livelihood. So it depends on the circumstances and the facts. It's very fact-driven exercise, so it's hard to answer the question in the abstract. The RTA does allow tenants to organize, to have tenants groups within their buildings, to not be penalized because they've taken steps to enforce their rights or make applications in the past. So the tortious interference, is that a end run for landlords when they can't really get at advocates for tenants? I suspect not in most cases. The difficult situation would be possibly rent strike. That might be the grounds for a tortious interference attempted claim. But you know, it's a lot of money to bring such a claim, to prosecute it, to advance it. So I think it'd have to be pretty egregious and the damages be pretty large before it would likely happen.
Okay, thanks for the answer there.
I can answer briefly the commercial tenancy one. It's a different act. It's the Commercial Tenancy Act, not the residential. And essentially everything is the way it always has been, except the courts aren't sitting and the sheriff isn't enforcing. So it's as much on hold as I understand as our residential tenancies in terms of a resolution or hearing, but that won't last forever.
Okay, thanks very much. Sorry, I was trying to communicate with our panelists behind the scenes. We have some compiled questions now. Should we, I'll just ask since we're all live, Jessica, would you like to go to some of the questions that we have ready, or should we keep taking some of these in the, Giles says, thank you, Ian, for your answer. Should we keep going? We have one more question here. Come on in and enter your questions in our live stream, and we're going to take some of our questions from, yep. So there was one that came up here about students, and I think we're going to go straight back to Ian for that because of his experience with students. And Jessica Burgess, I know, had some questions organized already in and around the students. So I'm going to pass it over to Jessica to ask some of the tenants questions on.
Sure.
So I think Ian has probably heard these questions, but some questions that are coming up in the media from students are the issue of, say, a student has signed a lease and they have had to leave the country for whatever reason. Do they have any options to get out of that lease, or what are you advising them if the student can no longer stay in the country or stay, in London where they've signed the lease?
So if it's somebody who's in a current lease, that's a little different than if it's somebody who has signed a lease, say for the summer or the fall, and now isn't sure whether they'll be able to attend or not. So dealing with the latter situation first, if you've signed a lease and it's executed by you, it's important to know, is that a lease between you and the landlord and anyone else has a different lease, or are you all under one lease? So it's possible if they haven't all signed, if it isn't on the standard form. So there may be ways in which you can get out, but it's very fact specific again. And I sorry to keep repeating that, but I would like to help more, but it's hard. So I think generally going forward, leases you haven't entered in, you've signed but not moved in, I think are fact specific, but generally you're going to be stuck. I suppose the practical answer, if you're in a foreign country, whether there'll be any steps taken to remedy that or collect the rent, they have to mitigate. They'd have to try to rent it out. So, I don't know what the damages would be. If you're in a current lease, then we're back to the problem we had before. And the only way to terminate it is in accordance with the RTA or the lease terms itself. I suppose if you had a number of roommates and you were worried about COVID spread and you couldn't properly self-isolate, there may be arguments that the lease is frustrated, but that's a tough legal test to set aside any contract based on frustration. So I think it'll be difficult, and it's fact specific, unfortunately. Oh, the landlords, sorry, is this question for me as well?
I think so. I guess I just saw that just pop up.
All right.
Can you bring that up again?
Yeah, it's right there.
Can you explain the landlord's duty to mitigate abandoned leases?
Yeah, any contractual party who finds the other party hasn't lived up to their obligations. So in this case, left their apartment, moved out, not paid rent, not given the appropriate notices. The landlord has a legal duty to attempt to mitigate. That means advertising the property, canvassing, interviewing potential tenants. And if there are tenants that are suitable and they don't take it, then they can be penalized for not doing it. And if they do take it, it mitigates the damages they have to claim against you.
Okay, great. I'm wondering if you've heard of any situations where someone, say, isn't covered by the Residential Tenancies Act, as we said, but they're in a roommate agreement, and maybe the leaseholder, or if they live with the landlord, wants to evict them. Do they have any protection if they've got a roommate agreement?
No one's jumping in on that one. Okay. I think that it's often a real shock to people to find out they're not covered by the RTA because they share a kitchen or a bathroom with the landlord's spouse, or the landlord's children. And essentially that means none of the protections under the Act. It's all lease based. Because the Act doesn't apply to you. So it's much more complicated and problematic. A tenants agreement, this sort of sounds like something Sheldon would have written. I don't know what a tenants agreement is. It's normally between the tenants themselves, how they will regulate their behavior and who will pay rent and who will buy groceries, etc. It's not usually with the landlord, which is the only way that you could tie a landlord in. So I hope that answers the question. But if not, I'm glad to elaborate.
That's great. Thank you. That's a big help. It's hard for the students. We hear from a lot of students. Some are going home. Some are uncertain about living in roommates, and there's been definitely a lot of questions. I'll say again to our viewers, thanks for coming. And we want to read just a quick reminder that we're not giving legal advice to people, but we're giving general information. We're asking our panelists to contribute. Jump into the comments, please, with any questions that you can think of. You know, all questions are good. Until we see a little more, we can continue some of the questions that we've already had from tenants. One thing that we're noticing with the coming on the market of some of the Airbnb rentals, or some of the student rentals are coming on the market now. And we're hearing from tenants that those are being offered as short-term leases. So they're not being marketed as Airbnbs, but they are being, advertised saying you have a year and then you have to go, or you have 8 months. And so the thinking is that the landlords are trying to weather the storm until they can go back to an Airbnb. What rights would a tenant have if they moved into a lease agreement? Betsy, could we start with you?
Sure, yeah, I'd be happy to speak to that. So I think this question, it's important to remember that, again, these are unprecedented times, and there's going to be novel scenarios or situations that come up that haven't been dealt with before. So there's not going to be a clear answer to all these situations. What the Premier, the Ontario government, has stated currently with the emergency measures is that short-term rentals are banned, if we think about Airbnb as an example, except for housing people who require housing. So if you don't have another residence or a place to live, a landlord can rent to you a short-term rental in lieu of a regular landlord and tenant tenancy. What does that mean is a different question. What is a short-term rental is a different question. Normally, you would think of a motel or a hotel or a vacation, spot, and those ones are clearly exempt under the RTA, which means you check in, you check out, and if you don't check out, you can be asked to leave. Where with a residential tenancy, you can't be asked to leave by your landlord without going through the proper process. If you're renting out a short-term rental during this time and it's for a year, I would suggest that's probably not a short-term rental. It is likely would be deemed a landlord and tenant relationship. And in Ontario, the law protects tenants that are in tenancies that fall under the Residential Tenancies Act. What I mean to point out here is that once a lease ends, you do not have to move out of your apartment or your unit. Your lease renews automatically on a month-to-month basis. Most people have heard of this. A landlord cannot require you to move out unless they have legal grounds to evict you. And a landlord cannot build into a lease a move-out date, which you have to comply with, a move in and a move out for leases that fall under the Residential Tenancies Act. So when it comes to a short-term rental, I would think that would be something like a few days or a week or two, and there's probably a single fee associated with that short-term rental that's known up front. But if you're getting into daily rates of your tenancy with no end, or weekly rates or monthly rates, that starts to look like rent, and that starts to look like a landlord and tenant relationship, in which case the tenant is protected under the RTA.
Okay, thanks very much for that. We'll just keep going with some of the questions. Now, maybe we should look more in depth. We had talked about what happens if tenants don't pay their rent, or either they can't, or in some cases, like Olaire mentioned with the rent strike, they don't pay their rent. And so we know that those hearings aren't happening. So, like, I'm just wondering if now would be the time to look a little bit at the N4 and sort of discuss so we know that the LTB isn't taking all the cases right now, but we do know that the landlords are able to serve whatever forms they want. And just so the audience is probably a little aware that the forms will come out in the form of the N forms. If tenants are receiving these N forms, maybe Olaire, you could speak to that a little bit. Let's stay on the N4. What next? So they've gotten this form, and maybe Louise could pull it up just so the audience knows what we're talking about.
Sure. Yeah.
Go ahead. Yeah.
Yeah. So it's the same for any kind of notice. If a tenant gets a notice, they don't necessarily have to move out on the date noted on the notice. So there's a termination date that is provided there. It's just for the landlord. It's a signal to the landlord that yes, they can file an application to evict the tenant. So tenants, landlords can't evict the tenants themselves. They have to get an order from the landlord and tenant board, and then it's the sheriff who enforces that order. So yeah, landlords can't change the locks themselves. It has to be the sheriff, and there's a process to that. And tenants are given their day in court to dispute or provide their evidence on why they shouldn't be evicted or why they shouldn't pay their arrears. So yeah, here is an N4. So it says here that the landlord believes that the tenant owes him or her a certain amount of money in rent, and the tenant should pay this amount by a certain date. Otherwise, the landlord can file an application. So there's a little bit of blurb here on what the tenant needs to know. So it's important for the tenant to read that so they're fully apprised of what they can do.
Thanks very much for that. I just want to clarify to your answer that this N4 is not the notice of the hearing. This would be a first step sort of form. And after that, the landlord could then apply for a hearing. And so just to clarify, then the tenants after receiving this N4 would then receive a notice of hearing if it was going to proceed.
Yes, and it's important for the tenant to be present at that hearing so they can dispute.
Thank you. We're just getting another question in, and I think I'd like to take it to Ian because we had touched a little bit on, where it gets into rights, human rights, charter rights. So this question comes from Chris, and it's regarding non-emergency repairs for tenants during COVID. And this question specifically mentions that they have an immunocompromised system. They're mentioning that the landlord has requested a doctor's note. And so could you talk a little bit about that? I'll see if there's anything else at the bottom of the question, but could you talk a little bit about that? Tenants who are immunocompromised, and these letting landlords in, non-emergent repairs, and disclosing health status to landlords. Is that a mandatory thing that a tenant would have to disclose to their landlord?
Well, to start out with the health status, no, you can't ask whether they do or don't. Landlords tend to ask what they want to ask. Whether they should or can is another question. And that's my own bias, so I admit it freely. But I think that in terms of getting a solution for the problem, sorry, I've lost my train of thought there. I'm sorry.
Yeah, no, that's okay. Just looking for a little bit more guidance too as to for the top of the question, what rights would tenants have to assert if they were trying to reduce the traffic?
Sorry, I got it. I just went.
Yep.
I answered the second part and lost myself. Yep. In terms of immunocompromise, I think we're all scared. at least we should be, of catching COVID. If you're my age, it's a lot more serious than I suppose the other panelists, because the elderly are the ones that are passing away. But if you have a respiratory condition or immune compromise that will prevent your body from resisting, I would explain it to the landlord. If it's a non-emergency repair, in other words, the pipes aren't bursting or the furnace isn't working or whatever, and it's just something cosmetic, I'm surprised they're even doing it now, but that's another thing. I think get the doctor's note. I don't know what the immunocompromise is in this particular individual, but if it exists, and I don't have no doubt that it does, it should be easy to get a note from the doctor. But I would have thought the landlord, with an explanation, I have this condition, I'm susceptible, and it would be hard for me to be treated if I got COVID, I'm not letting you in. And I don't think the LTB is going to look unfavorably on that, unless there is no immunocompromise or no support for it.
Okay, thank you. And I want to thank Chris for his question here, and I hope I'm getting it all straight. I'll just take the last part of the question. He has a hearing that was a tenant-filed hearing that's now been delayed. Betsy or Olaire, could one of you speak to what can he do, or what could he expect to see when hearings resume?
Yeah, I can speak to that. Again, it's a bit of a big unknown. So there have been about a month of no or few hearings already at this point. It doesn't look like the Landlord and Tenant Board is going to be opening back up for regular services anytime soon. Earlier I mentioned anecdotally there's about 100 hearings a week in London and Middlesex alone. So all of those cases need to be heard, and I would maybe suppose that when the board allows these cases to be brought forward at an in-person hearing again, that they may be done chronologically. That seems to be the most fair for the most part, that hearings that were scheduled 3 to 4 weeks ago that were postponed will hopefully be the ones to be heard first when we open up the floodgates, so to speak, going forward. But unfortunately, there's not much a tenant or a landlord could do to push forward their hearing date. The board has made their own decision on what hearings they are prioritizing now. For telephone hearings, they are very few, and again, they are, my understanding, predominantly issues involving a landlord's application where the landlord alleges a tenant has impaired someone's safety or is committing an illegal act. And for a tenant, if they have been illegally locked out of their unit and they are now essentially homeless, anything shy of that will less likely be prioritized and be given a hearing. And it's very unfortunate. I've heard some reference to these being deemed minor disputes. They're not minor. These are people's lives. If people aren't paying rent, landlords are, having financial hardship, and if tenants are living in, uninhabitable units, if there's serious repair issues or other serious interference issues with other tenants, it puts them in a very challenging spot. But unfortunately, the board is not as available at this time as they would normally be to intervene and address some of these issues. However, there are, as I mentioned, other agencies that are still open and available to some extent to address certain issues. If there are serious repair issues that might be considered a building code violation or a health and safety issue, property standards might be able to provide some insight. I don't know if they'll be doing a home inspection at this time either, but their agency might be able to provide some insight on whether they can provide assistance. If there is a serious concern for someone's safety, if there's problems with other tenants or a landlord in the building that someone fears that their safety is at jeopardy, the London Police Services can intervene in those situations. But otherwise, we're looking at tenants and landlords alike having to sort of have some patience and manage their issues to the best of their ability during this time, and perhaps do some self-help in the meantime. If there are minor repairs that need to be done and the landlord is not able to do them, and you've made that request in writing to the landlord to do those repairs and they need to be done, the tenant might consider taking it upon themselves, if they're able to do a minor repair, for example, and keep copy of any receipts of any costs that they had to spend to fix the problem. And then in the future, when the hearings are back up, ask for compensation if the landlord doesn't voluntarily reimburse them. But it's a very challenging time for everybody, and things are moving very slow, and it's very, very unprecedented.
Thanks very much for that. And that's some really good information. I just want to quickly clarify for the listeners, when we're talking about property bylaw standards, so that's the property standards at the city, and you can call the city and they will assign the tenant an inspector, and that inspector can actually come visit the property, document what's going on, and put some pressure on the landlord, right, to get some things done. And that, so thank you. We have another question, like before we go back to Jessica and the questions that we had received earlier in the group, we have another question that's sort of similar to one we received, or it's more of a comment that this person, Chris, and thanks for your comment, Chris, has a chronic illness, including a respiratory, got a doctor's, oh no, this was a response. So sorry, the one before that, the landlord wants to sell the house that they're renting. They have asthma and they don't want people touring. So it's not quite a question, but I'd like to take it to you, Olair, on a couple of fronts. So, you know, if people are, like, what are your thoughts on this? And also, if people are refusing their landlord entry and the landlord wants to oppose that, what might be steps the landlord would take to take that to the tribunal to be heard?
So I guess it depends, right? So if it's just to sell the house, the tenant can stay in the house until they get served with an N12 by the buyers of the house. But if it's for showing, I think they have the ability to refuse, especially if they have some respiratory illness or they are immunocompromised, just because the landlord has the duty to work with the tenant based on human rights grounds, that they can't discriminate based on disability. They have to work with the tenant, especially if they are immunocompromised. So I think that the tenant should try to negotiate with the landlord, maybe, see if they can go out on a certain day, go for a walk for 30 minutes, if the landlord's really adamant to show the place. But generally, they don't have to let the landlord in.
Okay. Thank you. Thank you for that. So tenants can know that if they're not comfortable, it can end, they have the option of not, or they're not able health-wise, if it's not safe for them, they do have the option. But then I understand there may be a bit of a debate at the tribunal afterwards, depending on what the landlord. I see some other questions here, so I'm just going to keep going with our live questions.
I think Ian was going to say something.
Yeah, just on the real estate question, the agent for the landlord will be motivated to sell. I know that many agents are providing cloth slippers, face masks, etc., for both themselves and gloves for their potential buyers. So, you know, if it really gets pushed to shove, that might be an avenue to call the agent and see what they're doing. That may help, and it just might make it a little bit easier. But I understand the concern, because somebody comes in your apartment or your house, you don't know what they touched, you don't know what to clean, so maybe you have to be there with everybody if it gets to that. But you know, I think most people will be more comfortable keeping them out for now.
Thank you. We have a really great question here, and we've seen this quite a lot just in our group, say, for London Tenants. Betsy, can a landlord ban or control the guests a person? So if a person is covered by the Residential Tenancies Act, can a landlord control who enters, especially in these times of COVID? Can they say, look, that's too many people coming and going, you need to stop?
Legally, no, there is no legal authority for landlords to ban guests. However, tenants are responsible fully for their guests and their guest actions. So if a guest is causing a problem and a landlord needs to address that problem, they can file to evict the tenant for the actions of the guest. So there is some control that landlords have when it comes to guests of tenants, but if they try to issue a no trespass notice, we would, suggest that that has no weight. It is the tenant's home. The tenant has the right to treat their rental unit as their home, and that includes having guests. You can have one tenant on a lease, and that tenant can bring in people to stay with them or to live with them, and does not necessarily need to report that to the landlord. The landlord really should not be interfering in the private lives of tenants. But tenants do need to be cautious on who they're permitting into the complex, because ultimately the responsibility of any problems falls back on the tenants.
Okay. And just to clarify, would it be what would you anticipate for the tribunal if the landlord was asserting that, say, you were having guests that were sick and that was jeopardizing other people and that was a danger with an N7? Is there any potential that a landlord may argue that, or what would you anticipate the board response being?
Yeah, I can imagine that a landlord might put forward that argument, but I think they would need more than just vague concerns that don't have a basis in reality. So if a tenant is complying with the emergency measures set out by the provincial government, so for example, not engaging in social gatherings with more than 5 people, if a tenant is complying with that, I don't see a landlord having grounds to evict a tenant unless there's something more going on. If there is a clear-cut case of a tenant that has very maybe obvious symptoms, and maybe that tenant is going around carelessly in the common areas and potentially and maybe deliberately or carelessly passing a potential illness, that is one argument, but I don't know how realistic that is. Realistically, what I would imagine is that tenants are entitled to their home and to invite who they see fit into their homes.
Okay, thank you very much. Now, we have an interesting question here from Jan Smith, and I am going to take it. Now, this is a concern that we also hear from landlords, where they're talking about that owners don't have a responsibility to make affordable units. But I think that we for people, but I think we could find a couple of different things to address in there. So one of the things I can think about is that there isn't now rent control between tenancies. Maybe somebody could speak to that and the effect it has on the housing. And I had another thought there for accommodations with people with disabilities. So we could talk a little bit about, is there a duty from the landlord to accommodate people with disabilities? So if a tenant, say, rented an apartment and they had stair access and they no longer can use stairs, would the landlord have a duty to accommodate a physical disability? Who on my panel would like to?
Well, I can start if you want. The Ontario Human Rights Code makes it illegal and improper to deny services on a number of grounds, one of which is disability. On the other hand, a landlord or any private business does not have a specific responsibility to provide units to provide units for people with disabilities. In other words, they present the unit, you take it or you don't. But once in the unit, there is the obligation under the Human Rights Code, which impacts the RTA because it takes precedence, that a landlord has some duty to accommodate a tenant's disabilities, so long as it's not an onerous thing to do. And that's sort of the word they use. So it depends, again, always in the law on the circumstances and the factual matrix that makes up the situation. In order to answer the question more accurately. But generally, landlords do not have an obligation to provide apartments for disabled people, but at the same time, they can't deny the apartment to disabled people. And secondly, once in the apartment, reasonable accommodations have to be made so long as they're not onerous.
Thank you. There's a lot to unpack there, and I suspect that each case has its own separate factual matrix that's associated for consideration. That's a good term.
Yeah, well, unfortunately, that's true. Yeah.
Yeah. So I have a follow-up question here regarding the no guest policy. So it says, what would a consequence be for a landlord? So I guess I would pose that, say if a landlord was policing a tenant to not have guests, what recourse could a tenant have? Say if they wanted to initiate a filing at the tribunal, what might that look like? What could they file? Who would want to be speak on that?
I can speak to that because that's a follow-up to sort of my earlier comments. Well, first of all, I would just, if possible, and if you're comfortable doing so, just to respond to your landlord, asking them politely that that they not interfere with you and your guests. You're entitled to access your rental unit in peace and reside in your unit in peace and have your guests over, and that they're not entitled to just, spy on you or keep, police your unit or see what's going on in normal circumstances. And if that doesn't fix the problem, if the landlord doesn't give you some space and respect for your home, and in fact, if it becomes a worse problem where they are perhaps stalking the tenant or harassing the tenant, first of all, if there is a concern for your safety, the London Police Services can be contacted if there's sort of a breach of boundaries and a violation there. If a tenant is feeling that their privacy and their security is under threat, contact the police whenever your safety is at threat. But for the landlord and tenant board application, there is a very common application called a T2 tenant rights application. And if you believe that your landlord has substantially interfered with your quiet enjoyment of the rental unit, you can file this application, explain your side of the story of what the landlord's doing that's substantially interfering with you, and ask for a remedy, which may include that the landlord stop engaging in those behaviors, perhaps also provide you compensation for losing out on the enjoyment of your rental unit while those behaviors were going on. Unfortunately, again, because the landlord and tenant board is not hearing cases in a normal capacity, an application like that may not be heard until the hearings are opened back up into in-person hearings. So again, if you believe that it's more than just the landlord being a little too nosy, but there is some serious boundary violations where you feel that they may be stalking you or threatening your security, contact the police.
Okay. And so I just want to follow up quickly, and then I want to go to Jessica Burgess with some of the questions that we had already received. But if I could just
I'll just add a little bit to that. So with the no guest policy, if, for example, if the tenant is affected in such a way that they can't go out because they're under quarantine and they have family members visiting, or not really visiting, but just providing them with groceries, leaving it at their doorstep, that kind of stuff, and they want something, they want a remedy that's quicker, they can also try calling the rental housing enforcement unit. They might be able to help. I know they're still open and they're still taking phone calls.
Thank you for that. And we'll be sure to post the phone number for the office, and that is where people can call right up. So I just wanted to follow up. I know they're not taking all cases, but they're taking some urgent cases. If it was a serious harassment that a tenant was experiencing, a T2 would not be eligible for one of these fast-forwarded cases?
I'm not sure. It's ultimately at the board's discretion. What I would do if I were to submit an application like that is put some clear, strong wording in the application that this is a very serious and urgent issue where your safety or security feels to be at risk, or that there is some time-sensitive nature to the application, and hope that the board acknowledge and prioritize a hearing. The board does review applications when they come in, even if they're not scheduled right away. They do have to field for cases that fall under their priority rules, but it's not something that you have much control over besides a request.
Right.
And I agree with Olaire, I should have mentioned it as well. The Rental Housing Enforcement Unit is another more timely response. If you haven't heard of the Rental Housing Enforcement Unit before, it's another provincial agency that polices the landlord and tenant legislation. So if a tenant or a landlord isn't following the rules of the RTA, the Residential Tenancies Act, that the a complaint can be filed with this agency and an investigation will be done, which typically looks like a follow-up call to the other party to sort out what the facts of the case are. And if there is an acknowledgement that the tenant or the landlord are committing an offense under the Act, doing something that they're not supposed to be doing, the Rental Housing Enforcement Unit can issue, well, first of all, educate, and that might be enough to fix the problem, but they might also be able to issue a fine or otherwise prosecute it.
Thanks very much for that. We'll make sure that we post that in the links for that resource. And I understand they're run through the Ministry of Housing and Municipal Affairs, so we'll post a link for that. That's great. Thank you. Jessica, do you want to go back to some of the questions that we've already received? And
Sure. Maybe we'll just keep on the live questions.
Okay.
We'll try to, we've got tons of great questions, so maybe we can just try to speed through some of them. I see there's a question from Breezy, and I don't know if we addressed that one already. I just wasn't clear on the question. I'm just wondering if you can maybe repost that as a question, because it wasn't totally clear to me. It was about moving with a respiratory weakness, and I just wasn't sure what the question was there. So we don't want to miss that one, but Breezy, if you can repeat that maybe, and just in the form of a question. Well, there it is. I think we just might need some more clarification about that. But maybe in the meantime, we can go on to Gwen's question. If the house I rent is sold, can the new owners raise the rent or evict me? In my lease, they need to give me 2 months notice.
I can deal with that one, or we can all. The new landlord takes the steps into the shoes of the old landlord. Any existing equities continue to survive the same obligations under the lease that dictated before. So if you're entitled to 2 months, you're entitled to 2 months.
Great. And then we've got another follow-up from Jeremy. Looks like still about the guests entering. What if they physically try to stop the guests from entering? In this case, they proposed a wristband system, checking wristbands at the door, almost like a concert.
I would say that the landlord has no authority to do that at all, and I would probably follow up with the Rental Housing Enforcement Unit to report that this landlord is doing this action affecting your whole building.
Yeah, and just to add something, I think that landlords assume that if there's already 3 or 4 people in the unit, that if you're now going to have another 3 or 4 people, you're beyond the provincial limit for groups and gatherings. So they're trying to help enforce the provincial restrictions. But I agree that it's your home. You have a leasehold interest, and you're entitled to have guests, and you take the risk of being charged for breaching some public emergency rule. So, in terms of stopping people and putting spans, I don't know what kind of apartment this is. It just seems a little bit overzealous by the landlord.
All right. And next question. This is about, sorry, I'm just reading as I go, from hoarding. This looks like a program to intervene. Okay, because I had found that London Middlesex Health Unit has a program to help hoarders, I believe. And Laura's following up, is there any help available to tenants who are willing to have help and are facing eviction?
Tina did post a link to that of hoarding support, whether or not they're active. It was run through the Middle Health Health Unit. And there's also a link to a hoarding support program on the Facebook page at London Tenants.
Okay.
And just to be clear, like if they're getting evicted, I mean, evictions are suspended until further notice, so they won't be evicted anytime soon, I would assume, if there's no application at all at the tenant board.
Okay, another one. What are the upfront fees a landlord can request from a tenant? And then the follow-up, if the rental was inaccurately represented, what rights do tenants have to refund the fees paid?
Well, generally, the landlord can ask and only ask for first and last month's rent. They can't ask for security deposit or other deposits, except maybe a key deposit, which is a small amount. It's set out in the standard lease form. So that's what they can ask for, and that's the only thing they can ask for. If you paid your first and last month, if I follow the question, I'm sort of reading it here as I'm speaking. If it was inaccurately represented, again, fact specific, what representation do you allege was made that you now find is false, misleading, inaccurate, and then you can maybe go from there. But I'd need more information to really provide any kind of general help.
Okay, that was from Ray KE, so maybe they can add a bit more clarification. Just trying to get through as many as we can. We got a question in advance from someone who wasn't able to attend, and this is more a maintenance question, so I don't know who'd like to answer this. But they're talking about their apartment building has more than 30 units and only 3 washers and dryers that break down constantly, and they're often left with only 1 or 2 working units at a time. The apartment building itself is minimally maintained. Unpainted walls in the main hallway, carpets aren't vacuumed or cleaned very often, massive stains. But the biggest issue is the washer and dryer that aren't working and should be replaced. And what should I do, since they don't seem to care much about keeping them in very good condition?
I can speak to that. The tenant can file a tenant's application. However, given COVID-19, I don't think it will be up to the board to determine if it would be an urgent matter. And like I think Betsy said earlier, the tenant should try to negotiate with the landlord on what options they have in trying to remedy this problem. So eventually, if the landlord really is not responding, the tenant might try to, or a group of tenants maybe can try to pull up some money and try to replace some washer and dryers. That's a stretch, but yeah, given COVID-19, I'm not sure what the landlord tenant board would say if this is an urgent issue or not.
Okay. There's also a follow-up from Gwen. I believe this was about if the building's sold. Can the new owners raise the rent substantially? Who would like to answer that? Betsy?
Yeah, so typically when a new owner purchases the property, whether it's a house or an apartment complex, the new owner becomes the landlord. The lease doesn't change except for the name that's written where the landlord's name would be. So all the other rights and protections that are guaranteed to the tenant under the law and by the lease remain the same. If your new landlord comes in and wants to do a bunch of renovations, spruce up the place, and then double your rent, they probably can't. The only time they can increase the rent above the guideline amount is if they file a special application when certain capital repairs are done, but not cosmetic upgrades or beautifying the place. A landlord can't increase the rent for that purpose unless the unit is exempt from rent increase. The rent increase guidelines, so newly constructed units are no longer protected by the rent increase amount, but all tenants are still protected by the 12-month rule, where your landlord can only increase your rent once every 12 months. It doesn't matter if the new owners step in between that time, the 12 months doesn't reset. However, it is important to note that the only potential negative change of having new owners step in is if they choose to move into the unit. If your lease has come to an end and you are on, or coming to an end and you're on a month-to-month lease, or if you are already on a month-to-month lease upon moving in, the new owners can apply to evict you so that they or certain family members can move in.
Okay, great. And we have another new question from someone who's on a fixed term lease until August 31st, but one of the tenants won't pay his share of the rent. I don't know if this is a joint lease or yes. And if we leave before the date on the N4, could he chase us for the remaining months on the lease? Who would like to answer that question?
I'll deal with that one, sure. If you're a tenant in common with the other tenant, the answer may be different than if you're joint tenants. It's most likely you're joint tenants, which means you each are responsible for all of the obligations, even if your co-tenant doesn't pay. So if you're the person with assets, income, money, whatever, and your roommate who doesn't pay disappears, they're going to go after the easiest person. So yes, they can chase you for all the rent that's due, subject to the duty to mitigate. You know, it depends on whether they do that in a commercially reasonable way. But yes, you can be chased for the rent.
Okay.
Can I
had asked
yeah, so but if the tenant is in receipt of OW or ODSP, those tenants are what they call judgment proof, so the landlord can collect from them.
Great, thank you. Ian had answered the first part of this question. We asked for more clarification from Ray KE about, this was about what if the unit was substantially different than advertised. So they're saying they provided fake pictures and the place is either non-existent or in a more damaged state than advertised. What rights do tenants have to refund fees paid? And I think they might have mentioned that they weren't able to see it in person due to COVID.
Okay. Well, I assume you know the pictures are fake, that there's absolutely no doubt about them being fake. So I assume you've seen the place and you've compared it to the photographs and it's a different place. And you'd like to get out of the lease. I think the first thing to do is to simply ask, to say, look, this isn't what you told me this place was. It's deficient here, there, wherever it is, and we'd like out, or we're going to have to take steps to have it declared void for other reasons. And then if that doesn't work, then you're kind of, you know, a little bit stuck in terms of what you do. But there would be remedies if you can establish that the apartment or the unit is substantially different than as represented. It would be a misrepresentation. It's a civil remedy. And, you know, we always get into the jurisdictional issues of who has to deal with it. And the common law does apply at the landlord and tenant board. So I would suspect the common law remedies for misrepresentation and for otherwise voiding an agreement would be available, assuming the factual proof is there.
Great, thank you. Question from Vicky: if an amenity is that's included in the rent is removed due to COVID-19, do tenants have recourse with a T3 for a reduction in amenity or the facility or the service? I'm imagining something like I don't know if there's like a gym or a pool or something like that in the apartment building that has had to be closed. I'm guessing that's what she means. Sorry, who would like to answer that? Betsy?
I can speak to that. My understanding is with a T3, it would be more for a permanent reduction in services. And there's a lot of regulation around what the service that qualify would be and how much the value would be determined and what that reduction on your rent would be. But I think for the purposes of COVID-19 and temporary shutdowns, I might imagine that the tenant could potentially ask for what's called an abatement of rent instead of a permanent reduction. Ask for essentially a discount on your rent for not getting what you would ordinarily pay for with your rent, and with the expectation of your lease and the building amenities. You pay a certain value to get a different value in return to you, and if you're not getting what you normally are used to, you're losing out. So that, I wonder if that might not qualify for an abatement. What I would probably suggest is, first of all, make a note of, you know, the date when the service was no longer provided, just so you can kind of track the timeline. Are we talking a day, or are we talking a few weeks or months down the line? See if the landlord's willing to maybe voluntarily provide some abatement of rent, couple percentage points perhaps. And then if they aren't willing to voluntarily decrease your rent temporarily, the board might, but there's no guarantee. This is, again, unprecedented times. So it's up, I would think ultimately it would be up to the adjudicators of the landlord and tenant board to see if they would benefit tenants and, you know, the various hardships or, you know, losses that it experienced at this time. I don't know if anyone else has an opinion about what that might look like.
Yeah, it's tricky.
A lot of the situations here are tricky, and I think most of the legal professionals in the housing world are sort of drawing on our past experiences of how different situations have been treated by the board and how the sort of legal framework would fit into this current situation. I think Ian mentioned earlier that the legislation hasn't changed. The rules haven't changed. There's just been, for housing purposes, landlord and tenant purposes, sort of a standstill and of, you know, process and a change in circumstances that is finding its way into the law that's never been before. So a lot of these questions are great questions and frustrating scenarios that people are dealing with, and we will find out a lot more in a few months, I think, about how, you know, where the law falls and who benefited or suffered more in these times, landlords or tenants.
Great. I'm just going to throw it back to Brandy now for a bit.
Awesome. Thank you. We will start to wrap it up soon, but I see a question here, and it does tie into what you were saying, Betsy, of that these are new times and that it's old laws, but with new considerations. So this is a question we're getting from Vicky K, and I'll just say that Vicky's an active member in a Ontario-wide landlord and tenant group, and so we're happy to see her on here, and welcome. This is a good question. If an amenity that was included in the rent is removed due to COVID-19.
Oh, we did that one. We did that one.
Okay, like a swimming pool or whatever. Okay, well, thanks, Vicky. I think, guys, the rest of the questions that are in here, we're just going to negotiate this on the fly. Jessica, do you want to, should I go to the couple of questions? There's 2 left. Let's finish them up. So Laura asks, does the tenant have any rights under the RTA if the lease only lists a domestic partner's name? So I'm guessing that this is a situation where 2 people have moved in, they've lived here the whole time, but only one of the couple is named on the lease. And so we touched on this a little bit earlier with who's named on the lease, but could someone take that over if they're domestic partners and they both live there?
Yeah, the tenant is the tenant. So whoever, if it's the husband or the wife who signed the lease, they're the tenant. They have the rights. They're the ones that have to deal with the landlord. They're the ones that have the responsibility. The spouse, partner, friend, +1 is simply a guest in the unit.
Now, Ian, can I follow up with a question there? If tenants are in a lease right now and they want to add their spouse onto the lease so that there's a feeling of safety or that everybody's covered by the residential or for whatever reason, are people able to, I know they can ask, but are there any rights in terms of adding on another tenant to the lease that tenants would have?
Well, it shouldn't, if the tenant's willing to do it, it shouldn't bother the landlord. The landlord should be happy to have another person to pay the rent, to deal with the responsibilities, to talk to. So I doubt it's a landlord problem. And I think it's a very good idea, especially amongst domestic partners, because if one person's on the lease, they can give a notice to terminate the lease. And the next thing you know, you're going to have to leave in 60 days when they've taken off. So this would protect you as a tenant.
Great. I want to add in what I think is a really important question that I don't see on the screen. We're hearing these times that there's a significant increase in domestic violence. You know, I see a lot of that around anyways. And then with people being in their houses, we're definitely seeing an increase. Now, I do understand there are some provisions for breaking leases, say in a domestic situation. What are some of the things that people who are in a domestic violence situation could consider at this time?
Yeah, so there's a form called the N15. It doesn't need to go to the board necessarily. There's not going to be a hearing for that. So what the tenant who has experienced abuse can do is they can fill out the form, give it to the landlord. The landlord is under the obligation to keep everything in that form confidential. So the form also gives the tenant 28 days to leave. So that means that he or she can break the lease within 28 days.
That's great. Thank you. So we have a last question here, and then I'm going to pass it back to Jessica to wrap up. And oh, there may be 2 more, but we're going to, sorry, I'm bad at this.
I think it's just a continuation of Coodle Doodle's question. So the person that's leaving was on ODSP, so they're judgment proof, as we've discussed. The rental arrears are $7,000, and if it went to debt collection and wage garnishments and all that sort of stuff, am I going to be stuck paying? And the answer is possibly. If you're all joint tenants, you're all equally responsible for the entire monthly rent. Even if you've already paid what you perceive as your share, you remain responsible for every other share in the unit until it's paid.
That's great. Well, this has been a really good opportunity, and we're really thankful to everybody who showed up to ask questions and to our panelists. I'll just pass it to Burgess for the official wrap up, and this has been just great. So thanks, and hopefully people can find the services that we've mentioned in the comments, and if there's any follow-up questions, find us at London Tenants, and we'd be happy to point you in the right direction.
Great. Yeah, we'll try to post links to the resources that we talked about. I know there's a few that we need to add, including the rental housing enforcement unit. We do have some links to resources at londontenants.ca, I believe. But before we wrap up, I just want to say a huge thank you to all of our panel guests, Betsy O'Leary from Neighborhood Legal Services and Ian from Western Community Legal Services. I want to give everybody a final word, and I also want to give a huge thank you to the London Poverty Research Centre for facilitating this webinar and the tech skills and the connections and helping us make it happen. I think it's obvious that a lot of people have a lot of questions, and I'm really glad that people got some answers to their very unique questions. So I just want to throw it over. Let's sort of do a round table. Starting with Olaire. What would you like to say? Any final words? Any that you'd like to leave people with?
Yeah, sure. Yeah. First, thanks for having us. And I guess my final words, it would be, if there's any problems with your landlords or your landlords have problems with the tenants, don't try to hide from the landlord. Try to negotiate, be as respectful as you can. Keep an open mind. Usually negotiations are better done outside of the landlord and tenant board, and you can get more positive results that way.
Great, thank you. Betsy, anything you'd like to add?
Yeah, I would like to also extend my thank you, especially to all the attendees today. I think it's wonderful that people are curious about their rights and responsibilities, and I think it's also important to keep informed. There's a lot of information on the internet, a lot of information that you hear, but it is good to be aware of how the rules work in our area. We're, again, a London-based organization, but what we talked about today extends to all of the province of Ontario. There are legal clinics all across the province. If you are a tenant and you need, or if you have any questions about your rights, we have free advice through a Tenant Duty Council. So you can go to Legal Aid Ontario to see the clinic in your area. And for London and Middlesex, it's nlslm.com. The website was up. I think you'll have it available through the London Tenants Association as well. And I just also like to note that for small landlords, there's help out there for you as well. If you can't afford a lawyer or paralegal to advise and represent you, there's another independent legal clinic that caters only to small landlords and advises small landlords, and that's landlordselfhelp.com.
Great, that's great to point out that resource. Ian, any final words from you?
Just to everyone, stay safe, stay strong. Remember that because you're a tenant doesn't mean you're less worthy or entitled to rights because someone owns the unit you're in. Stay strong. It is your home. It's your family place, and treat it with respect and treat your landlord with respect, but keep your own respect. And I hope we can help, and we have helped tonight. So take care.
Well, thank you very much for providing the expertise, and I think everybody got a lot out of it. I'd also like to say, if you are a tenant, we're just trying to form as a peer support organization. We're just getting some information up on a website, londontenants.ca. We've got a core group of volunteers that we were just starting to meet with before COVID happened, but please get in touch if you want to volunteer. We're just trying to connect people with the resources that are out there and provide information on what resources are out there. So please connect with us afterwards if you have any outstanding questions, and we'd like to try our best to point you in the right direction. And Brandy, is there anything you'd like to say? I'll let you have the last word.
I just think that this has been really good, and I hope everybody has benefited in their own way as I have. And so thanks again to everybody, and good night. Thank you.
Thanks.
Thank you. Thank you. Are we still on?